colleagues. My presentation will be, I suppose, rather short. The topic of my presentation is, as you can see, international commercial arbitration. What is it? Arbitration is a legal technique for resolution of disputes outside the courts, where the parties to a dispute refer it to one or more persons, the arbitrators, arbiters, or arbitral tribunal, by whose decision they award they agree to be bound. So in bold I have highlighted points of the arbitration, the major principles. Because, first of all, arbitration is an alternative to state court. So when you agree to arbitrate a dispute, unless you have decided not to arbitrate it after you conclude arbitration agreement, you cannot go to a state court. You have to refer your dispute to some kind of arbitration. It depends on your agreement. The second point is that your dispute will be decided by some people. People often you choose, but it's not a military point, military norm provision, but still it's common practice to choose your own arbitrators. The very important part is that the decision which is rendered by the tribunal, by the arbitrators, is still bound to the parties, because they are bound to respect this decision and to comply with it. If the parties do not comply with it, the party which won their arbitration, which got its damages, for example, it can refer this award to a state court, and the state court can issue a document which will make it possible for that party to enforce this award. Major pros, major reasons for choosing arbitration. First of all, neutrality. It means that, for example, if two parties, two companies from different countries enter into a contract and some disputes arise, the dispute will be decided in one of that countries usually, if there is no arbitration agreement. And it is possible that the court of the country in which this dispute is being decided will be more preferable, more friendly towards the party from this country. And it's a quite important problem, because there is a long practice of such decisions, which can be quite doubtful as to their neutrality. And when you refer your dispute to arbitration, the arbitrators you choose usually are from different countries rather than the parties to the dispute. It's not a rule, but still it is a practice, common practice in arbitration. Second point is enforceability. When you have a state court decision from one country and you have to enforce it in order to get your money or property in another country, it is not easy to get this enforcement, because enforcement of state court decisions is reliant, depends on different bilateral, for example, bilateral agreements between the countries. And unfortunately, even now, it is not guaranteed that having such decision you will be able to enforce it. The third term is confidentiality. In most countries, state court proceedings are not confidential; they are public, and quite a lot of people can visit the disputes you're participating in your company, and it can be quite a valuable source of information for the other companies in the same sphere.
So you get publicity then?
Yes, yes, and it's not very good for a lot of companies. Of course, you can ask judge to hold proceedings behind the closed doors. Fourth point, speed and efficiency. In our country, we have quite efficient state courts system, because you can have your dispute decided, maybe, for example, 2 years after you have filed. And arbitration is quite speedy, is quite fast mean of resolving disputes, because there are no appeals. So you can refer your dispute to arbitration, you can have the award, and then the award can be reviewed only with purpose to decide whether there were some procedural violations. No substantial violations can be revised. There can be no revision of the award in this part. That is why you can have your decision maybe in a year, maybe in 2 years. It depends on the nature of the dispute, and still it is quite a speedy way of dispute resolution. Expertise. Sometimes, especially transboundary contracts, have to be referred to experts. Sometimes it is important that the judges, the arbitrators in our case, for the arbitrators to be experts in the field, in the particular field the disputes arise in. And the final point, it's not the final point generally, but I have highlighted these six. Flexibility. It means that when you take part in proceedings in state courts, their civil code or the arbitrage code, in procedural code in our country, you cannot change it, you cannot choose it. These rules exist before you refer to the dispute. When you refer disputes to arbitrators, you choose the proceedings, the procedural rules yourself, with your counterpart, another part of the dispute. So you can have more flexible, more easier way to decide a dispute. With us, for not choosing arbitration. Arbitration is not a panacea. It's not an ideal way of deciding the disputes. First problem: inability to join additional bodies or claims. It is all about consent. The second problem is potential need for court involvement. Sometimes you have to make some rapid actions in order to preserve some sums of money, some evidence, and so on. And tribunal is not a very efficient way to get these actions done, because you have to form the tribunal, you have to choose the arbitrators, you have to pay some of the money to arbitration institution, and so on. And that's why you have to refer some parts of your dispute to state courts. The last point I have already referred to it, lack of right to appeal. So if you think that you have been treated unequally, your arguments were not heard by the arbitrators, and you still believe that you were right in your actions, you can do almost nothing. You have to live with it, because almost nothing can be done to review their arbitral award. You can only stipulate that there were some bias on the part of arbitrator and try to render this award unenforceable, or to do something like that. So you have to use only procedural means to make these awards useless for your opponent. Well, the main documents which make it possible for arbitration to exist and to be efficient way of disputes resolving. First of all, Convention on the Recognition and Enforcement of Foreign Arbitral Awards. It's a very important convention because a lot of countries, more than, I'm not mistaken, more than 120 countries joined this convention, and it makes it possible for parties to enforce agreements rendered by tribunals in different countries in all the countries parties to this convention. So there will be a map of the countries which joined this convention, and you will see that almost all the countries, especially economically developed countries, are parties to this convention. And that means that you can arbitrate your dispute anywhere you wish, almost anywhere you wish, and it will be possible for you to enforce your award in other countries, almost all the countries you may need. The second convention is the Convention on the Settlement of Investment Disputes between states and nationals and of other states. It is so-called Washington Convention. It's quite important as well. It is like the previous convention, but for investment disputes. It provides for creation of an arbitral tribunal for investment disputes, and it is called one of most successful international documents in the sphere of investment and arbitration. Ancestral model law on international commercial arbitration with revisions in 2006, it shows that this law is adopted by many countries in the world. It is adopted by maybe 100 countries. It means that when you arbitrate a dispute in the countries adopted this law, which incorporated the provisions from this law in their national legal systems, you face almost the same provisions in all these countries. So you will not, possibly you will not be surprised by some provisions of that laws. Ancestral arbitration rules, it is not very popular because it is created only for ad hoc arbitration. I mean the arbitration which is the tribunal and the maybe institution is created only for one dispute. And then it dissolves, it is maybe we can call it destroyed, because the dispute is decided and that's all. Today the most important and the most popular way of arbitration, there are two types, ad hoc and institutional. Institutional arbitration, when there is an institute, an organization which provides some administrative functions, some administrative service for the parties who decided to arbitrate. And their last document, IBA Rules on Taking of Evidence in International Commercial Arbitration, it is some kind of procedural code for some very often used actions of taking of evidence in international arbitration. Well, and maps. So, EXCEED is their Washington Convention about investment disputes resolutions. So you can see that a lot of countries joined it.
Sorry, and what is the difference between the two green colors?
Yeah.
Well, if I'm not mistaken, these countries joined this convention but not ratified yet.
And sorry,
yes.
What does the red countries do?
Red, they exit. Ancestral model law implementation map. So I have told you about model law. You can see that again almost all the world implemented this model law. It means that again you will not be surprised by the way arbitration will be conducted in different countries. Map is New York Convention parties map. So you can see even more countries join this convention, and again it means that their parties to commercial disputes, international commercial disputes, can freely and with confidence arbitrate their disputes in different countries, and they will not face problems with enforcement of their arbitral awards. So three main organizations in the field. There are a lot of organizations, but I have chosen this. So thank you for your attention.